Before I get started, I'd just be curious as to how many folks here have been involved in the disciplining of a fellow club member. And just as a second question, how many of those in those instances do people have was alcohol involved in some way, shape, or form in the? Yeah, so I think we get an idea of what some of the issues are with respect to disciplining members. Serious instances of misconduct by an employee or a member can create serious problems for a club. The most obvious one is litigation. You have a member who is involved in something with an employee. You can have the employee suing the club as well as the member. If you have a member who's terminated, certainly that could result in litigation, or similarly with an employee who is terminated. It can be terrible publicity for a club if you have a situation involving serious misconduct. It's the type of thing I think that newspapers eat up and would be happy to publish. And that can hurt the club brand, and then it resultingly can also affect recruitment membership. And finally, there's internal divisiveness in the club, which can result if a popular member is terminated or a popular employee is terminated. To give you an extreme example of a mishandling of misconduct by members, there was a case that I think many of you are aware of in Massachusetts, in the Haverhill Golf Club, in which a number of female members sued the club claiming discrimination on a variety of grounds. Primarily, and the one that got the most publicity was the preferential tee times. But in the course of that decision, in the appellate court decision, they discussed some of the evidence, and one of the pieces of evidence was that one of the plaintiffs, a female member, had been disciplined. She was suspended from playing golf for 21 days because she'd held a couples tournament and allowed people to participate who did not have USGA handicaps. So she was suspended for 21 days. The court compared that to a situation in which members of the club, including board members, and this is language from the court's decision, had cavorted in the buff in the club pool with female employees. And the response to that, from which the court indicated was also against the rules. And the response to that from the club board was that happens all the time, and there was no discipline. So this was part of the evidence was relied upon, as well as a variety of other things, which resulted in a judgment of roughly $2 million against the Haverhill Country Club. So hopefully that doesn't happen a whole lot, but it can have serious consequences. Basically, when you're dealing with member misconduct or you're dealing with employee misconduct, the same basic rules apply. There should be clear notice of the type of behavior that's prohibited, a code of conduct, if you will, both for members as well as employees. There should be an investigation to determine whether what is alleged actually occurred. I mean, many times you'll find that somebody will take the word of just one or two people. You shouldn't do that. There should be an effort to investigate the underlying misconduct. And finally, next there will be fair process. Any court which is going to review a termination of an employee or a termination of a member is going to look to whether there was a fair process which was used. And generally in the law, that requires two things. One, that there be notice of what the person is alleged to have done, and number two, they should be given an opportunity to be heard. And finally, there should be documentation of the action, whether it be against the employee or whether it be against the member, because that can be used later on in terms of progressive discipline if there's a recurrence of the misconduct. Some of the most common examples of member misconduct: cell phone use. Michael talked about that a little earlier. It's important to have a policy which is both reasonable and enforceable. We struggled with that at our club over several months. It's unbelievably controversial issue. When you talk to somebody outside the club setting, they think you're nothing short of nuts, that this is what you're involved in. But it's an important issue. And I think what has to happen is it has to be enforced reasonably and fairly. You can't just pick the one or two guys that maybe are going to take the hit without complaining. You have to enforce it across the board. And it's, I think, a very, very useful lesson that suspending a couple of the serious offenders for a short period of time does wonders to getting respect for the policy across the board. Cheating, obviously. Cheating, generally speaking, I would think that that's something that should be taken care of by the golf committee, but in a serious incident, it could, or recurrent instances, could go to the board level. Disorderly behavior, generally, I think that we can recognize that involves alcohol most of the time. I was playing a member guest a number of years ago, and there was in our foursome there was our opponents had there's a very obvious rules violation that had occurred, and I was telling my host that he should bring it to the attention of the other side, and he said, "No, I don't think we're going to do that." And I said, "Why not?" He said, "Well, this guy that we're playing had he was suspended from the club a couple of years ago because he got into a fight in the bar and he bit another member's nose." So we didn't raise that particular issue. The most serious issue, and the one is really that has to raise a red flag to club officials and board members, is sexual harassment. And this is something that can really, really create liability, embarrassment, bad publicity across the board. And there's a variety of issues about it which make it particularly problematic. I think in the club setting, there's a tendency in some instances to view it as innocent behavior and to look the other way. You know, that's just Charlie. That's just the way Charlie is. He's just kidding around. It's not important. But those innocent or seemingly innocent instances of harassing or flirtatious behavior can show up later on in a lawsuit and can really be used to bolster a subsequent sexual harassment claim. The second issue is the reluctance of employees to report sexual harassment. You have young women who work in the restaurant. They don't want to report it because they're afraid of being ostracized. I think you have to tell your employees, particularly the younger employees, that this is very important stuff, that if it occurs, you have to bring it to the attention of the general manager, and that the board and the general manager will support you fully if you do that. Otherwise, again, when there's finally a claim, whether it be in a court or an administrative agency, all these prior incidents, which you may not have known about, are going to come to the fore and really come back to bite you. The next thing is there's the potential that some victims are going to view this is a potential payday in the world we live in. You have wealthy, well-to-do members of clubs that view it as something that they can make a little bit of money over. And particularly if you have a young girl who's working in the club, something happens, they can go home to their mom and dad, and the next thing you know, you're involved in a lawsuit. Impact to a club from a sexual harassment claim. There's a body of state and federal laws which create liability not only for the member but for the club. Failure to address it, as I indicated earlier, in a variety of earlier situations can be used to bolster a future claim. And finally, there's the damage to the club's reputation, as I indicated before. A lawsuit alleging sexual harassment is going to be news, and it's going to hurt the club's brand, and it's going to hurt the ability to obtain new members. So the clubs have to have clear policies prohibiting sexual harassment, and when you have these kind of allegations, you got to take steps to discourage it and address it as it occurs. In terms of member misconduct generally, there's a variety of factors which make it particularly difficult, and certainly much more difficult than disciplining employees. First situation is it's difficult to discipline friends. These are people that you're going to be on the golf course with, you're going to be in the grill room with, and suddenly you're in a confrontational situation with them. That makes it very, very difficult. Secondly is the difficulty in maintaining confidentiality. We all operate in a very small community in which there's a rumor mill and discussions, and if these things are not handled appropriately, it's going to hurt people's reputation. It is not unusual for members to leave a club just simply because of allegations, because regardless of what the ultimate action taken against them is. The next thing I think that you have to take into effect is the emotional attachment of members to the club. Anybody who's a member of a club is an important part of their life. And, in many instances, it's a way too important part of their life. And so when you have a challenge to that membership, you're going to get a very, very significant reaction many times. Next, you have many members, or most members by definition, are successful people, and they're not used to being told what to do. And being challenged by the club or by the general manager concerning something that they did is going to get a very, very strong reaction. I mean, I think that from a board level or from the general manager's level, when we've had these kind of situations, what all anybody wants to happen is for the member to come in and say, "I'm sorry, I had too much to drink, I love this place, I won't do it again." Surprisingly, that in many, many cases, that is not the reaction. We get these involved offenses, and we had a member at our club a number of years ago who had gotten had way too much to drink. Had been abusive to one of the wait staff, and when we confronted him with the fact that there were chits for 13 beers that afternoon, his reaction was, "Well, actually, I had this friend there who really drank most of them. I only had a couple, and no one else in the club saw any other friend, and there was no record of this, what turned out to be basically an imaginary friend." So as a result, you have to, when you're handling these situations, there's a lot in play, a lot more in play when you're terminating or disciplining an employee for misconduct. And there's a real need to handle it discreetly, promptly, and fairly. In terms of a system for addressing member misconduct, the first thing is that there should be a code of conduct indicating what are the rules and what kind of behavior is expected. Ideally, that should be reviewed with a new member at orientation, and have them sign off on it at that time. You don't want to have a situation where a member is accused of some violation and saying, I didn't know that was the rule, which happens more in many, many instances. You should investigate the allegations promptly. Lyndon Johnson had a saying, don't let dead cats sit on the porch. And I think that that's, as these things sit and fester, creates more and more of a problem in terms of creating divisiveness in the club. In a serious case, you should use outside counsel to do the investigation. That underscores the importance of the allegations. It provides for objectivity of the investigator, and it keeps both management and the board members out of it. And next, you should avoid selective enforcement. There are members who are maybe very popular members. There could be everyone likes them, and there's a tendency to look the other way when they do something, and somebody who's perhaps less attractive, less popular, gets whacked for the same type of offense. And you really have to avoid that. You have to enforce all the rules as fairly as you can. Again, you should utilize a fair procedure. There should be written notice of the allegation against the member. There should be an opportunity to be heard before a grievance committee, and then some sort of an appeal process to the board. Again, and I've stressed it a couple of times, confidentiality should be maintained in all respects with respect to that. It's very hard to do, but you should have to the extent possible, limit the number of people who are involved in the investigation and dealing with the offense. And finally, the results should be memorialized in the member's file, so that again, if there's a recurrence of any type of misconduct, you'll have a basis for what's called in the law progressive discipline. Just want to talk very briefly about at-will employees, because many times people employers who have employees who do not have a contract view them as at-will employees who they can terminate at any time for any reason. This is most certainly not the case. There is a large body of federal and state laws which preclude discrimination against employees, and these become very much in play when you terminate virtually anybody. There's Title VII, which prohibits discrimination on the basis of race, color, religion, sex, and national origin. There's the Age Discrimination in Employment Act. There's the Americans with Disabilities Act. There's the New York Human Rights Law, which prohibits a wide variety of types of discrimination. There's the Workers' Compensation Law, which prohibits discrimination against people who file workers' compensation claims. And then there's OSHA, the Occupational Safety and Health Act, which prohibits discrimination against anybody, or retaliation against anybody who files a claim under that act. And the way these things come into play in the law is you will have somebody who is terminated. They will then make a claim that the real reason that they were terminated was their religion or their race or whatever. And the court or whatever reviewing body will then be required to show the real bona fide business reasons for their termination, that they had a substantial basis for the termination. And if you can't do that, it's going to give credence to a claim that otherwise really is frivolous. The judge is going to look at it and he's going to say, if they can't give us any substantial reasons for the termination, maybe there is some value to it. And they may not win the case, but it's going to give it legs to allow it to go through a long process. And the way you get around this is to document misconduct when it occurs, to document poor performance when it occurs, and to have a record which you can show contemporaneously to a court. Just to give you a brief example of that, we had a situation at our club where there was a new employee who was working in the office. She was not doing a good job. She was being criticized by management, or they were giving her some indication that she was not doing a good job. And somewhere along the line during the first couple of weeks, she said, you know, people don't like me here because I'm a Muslim. And no one knew she was a Muslim before. No one had any idea she was a Muslim. But suddenly she had developed a what was sort of a get-out-of-jail-free card on this. Fortunately, in that instance, she left voluntarily. There was no lawsuit, nothing happened. But those are the type of situations where you can really end up in an exposed situation. So, thank you very much.